Okay, hello and welcome to the ABA section of Civil Rights and Social Justice Chair Chat. I'm Cynthia Swan, Vice Chair of our section, and I'm delighted to welcome you to this CRSJ platform. These Chair Chats provide a unique opportunity to engage directly with the key issues at the heart of our work in civil rights and social justice. They are designed to foster meaningful dialogue, to deepen understanding, and offer valuable insights from leading experts on the most pressing civil rights and social justice challenges of our time. Today's program focuses on the Supreme Court's recent decision in Louisiana versus Callais, including the history of the case, the court's rulings, its broader legal implications, and what it may signal for the future of voting rights and redistricting jurisprudence. We are honored to be joined by Janai Nelson, President and Director-Counsel of the NAACP Legal Defense and Educational Fund, and Paul Smith, Senior Advisor and Visiting Professor, Georgetown Law, and Chair-elect of the ABA section of Civil Rights and Social Justice. Attorney Nelson argued Louisiana v. Callais before the Supreme Court and is one of the nation's leading civil rights advocates, and Professor Smith is a distinguished legal scholar and experienced Supreme Court advocate who has argued numerous cases before the court. Professor Smith will guide today's discussion with Attorney Nelson as they explore the decision and its significance. And with that, I will now turn the program over to Professor Smith to begin the discussion.
Thank you, Cynthia. Let me add my welcome to everyone who's joined us and say how thrilled I am to be talking to you, Janai, about this case. I must say I got to watch you argue it twice, once in the moot court at Howard and then at court, or at least I listened to that one, and you did a spectacular job, even in a losing effort. But maybe we should start. I know you've probably been doing this a lot in the last week or two, but tell us a little bit about the issue that crystallized in the Louisiana versus Callais case at the time you got up there to argue it last fall, and then maybe a little bit about what the court did on that issue, unfortunately.
Sure. Well, Paul, it's great to see you again. And I just need to thank you publicly for being part of the moots that I did in preparation for this pretty historic argument in this case. So what brought the case back to the court a second time was clearly a concern on the part of some justices about whether remedial districts, meaning districts that could remedy the harm of racial discrimination, are doable under Section 2 of the Voting Rights Act, whether they pass constitutional muster under the 14th and 15th Amendments. That was ultimately the question presented in the case. And this case, I think it's very important to note, was before the court for a second time, because we actually had argued the case in March of 2025, and we were awaiting a decision, which we expected to be issued in June. And instead, we were told that the court was holding the case over for re-argument. And in August, we got the question presented, which was exactly that, whether the remedial district in Louisiana that we won because we proved that the state had discriminated against Black voters in Louisiana on account of their race, whether the district that we got as a remedy was lawful under the 14th and 15th Amendments. And that was the question we presented, or what we answered. And unfortunately, the court issued a decision 2 weeks ago now, suggesting that that is not a valid remedy under Section 2. There are many reasons why I fully disagree with the reasoning of that.
We'll get to all of that. Yeah, just to sort of help with the setup here. Your claim for a second Black majority congressional district in Louisiana, which the state eventually acquiesced in because it was such a strong claim, certainly met the standards that have applied under Section 2 of the Voting Rights Act for the last 40 years, which is to say it was possible to create an additional reasonably compact district, and there was a very high degree, and is a very high degree, of polarization in voting, so that if you just create white majority districts, you'll get the white candidates of choice elected and not the African American candidates of choice. And so that's the problem that the Section 2 was meant to address, especially after it was amended a little over 40 years ago. And that's the problem it has been addressing effectively for the last 4 decades. And suddenly the court came in and said, well, we're no longer going to have that Section 2. We're going to read the statute differently now because we think that there's such a major constitutional problem looming over this, which is if a state intentionally creates an opportunity district for African Americans to elect a candidate of choice, that itself presents a constitutional problem. So tell us a little bit more about how the court got to the idea that we're no longer really going to have a meaningful obligation to create these opportunity districts.
Yeah, I will absolutely get to that, but I also think it's important for people to know some of the conditions in Louisiana that led to this.
Sure.
Louisiana, is a state that is 33% Black. It has the largest percentage of the Black population of any state outside of Mississippi. So it has a significant concentration of Black people who vote, as you said, in coalition with one another in most elections and are often defeated by the white vote. Their vote is often canceled out, and that's proven in statewide elections where a Black person has never been elected by their fellow Louisianans. So there's clear proof, in addition to so much other evidence that we presented, that the redistricting map that the state originally passed discriminated against Black voters because it did not allow the population of Black voters in the state to have an equal opportunity to elect candidates of their choice. Now, Louisiana has 6 congressional districts, and at the time we brought our case, there was only one district out of those 6 to serve that 33% Black population.
Right.
And so we fought for a second district, which was, not even quite proportionate. White voters still were overrepresented in their congressional delegation. That said, after we won that case and 6 federal judges affirmed that finding, we found our remedy, that creation of a second district that would allow Black voters an opportunity to elect a candidate that they chose. We found that district challenged by self-titled non-Black voters. So people who were in the second district and for some reason did not want to come out and identify themselves as white voters, they challenged our district and said it was unconstitutional. And that was, in fact, the case that was brought before the Supreme Court. So you had the separate case that we won, and then you had this collateral attack on our remedy.
Right. And part of this attack initially was that the way the state chose to create that second Black majority district was kind of long and stringy, more long and stringy than it needed to be, because they were trying to simultaneously protect all of the incumbents that they cared about in Congress. And so they created essentially the opportunity for a so-called Shaw v. Reno racial gerrymandering challenge to the remedy map that the state chose to draw, thus creating some risk for the whole case. In the end of the day, though, the court didn't decide it on that basis about the shape of that district. It focused on the underlying question of when does Section 2 require the state to create any kind of Black majority district? And it rewrote those standards in a way that pretty much makes this statute go away. It's not going to have it. We're just not going to see states being forced to give any kind of opportunity to minority voters, even in the face of really polarized voting in the future, given the way the statute has been, I would have to say, distorted.
That's absolutely right. And the reason why this case is so devastating and alarming is when you look at those underlying factors. And so one being that there were many other maps that the state of Louisiana could have chosen that would have remedied the racial discrimination that we proved. The reason that they chose the district map that had the elongated second district was because they wanted to preserve the seats of, people like Mike Johnson and Stephen Scalise and others, which they were perfectly entitled to do as part of their interest in preserving the delegation, the existing delegation to Congress. And so the state was balancing its political interests and its duty, its constitutional duty to remedy race discrimination. And that resulted in a second district that was elongated and stretched across the state. Now, what we argued as part of our case in Callais the second time and the first time is that, if the court in any way felt that the remedy we relied on and that we negotiated with the state and that the state originally defended, if they thought it was wrong or it violated the Constitution in any way, it should jettison that remedy, remand it to the district court, and we could come up with another better suited map to address the concerns of the court.
Maybe one that looked more like the map you guys had submitted in the first case.
Well, there's that. We already had a map in hand. We would have been happy to just pull it right back out of our pockets and put it on the table. Yeah. But instead, the court did so much more than was necessary in this case. Instead, the majority in the court, 6 justices, rewrote the test that allows us to challenge district maps that discriminate on the basis of race. It said that Section 2 now requires plaintiffs to prove that not only the population that we are defending is sufficiently large and geographically compact and all of those already difficult burdens and barriers to surpass, but we would need to show that any remedy we proffer did not consider race at all. So we're remedying race discrimination on the one hand, or we're proving race discrimination on the one hand, but when we serve up a remedy to that discrimination, we have to kind of do that blindly. We have to.
That's what's so bizarre, that passage in the opinion that says you have to come up with a demonstrative map that shows it's possible to have an additional Black majority district, but you have to draw that map without thinking about race in drawing the district.
It's unclear how you do that.
Idiotic.
It's idiotic and utterly impossible.
Right.
And then secondly, not only do you have to do that, not only do you have to undo the discrimination without keeping race in mind at all.
Thinking about it, right? Yeah.
Yeah, which is the factor of discrimination that you are trying to address and remedy. You also have the special burden of making sure that you also meet the political goals of the people who discriminated against you. So I just want people to think about that. The folks who are using race to discriminate against groups of voters not only have to proffer a remedy that doesn't consider race at all. So, good luck trying to make sure that you remedy it, but you also have to carry the burden of the people who discriminated against you and make sure that you do their bidding for their political goals.
Let's just tease that out so make sure people understand what that means. So what the court said was, if the state's map that you're attacking is discriminatory, included 5 white majority Republican leaning districts, you have to come up with a proposed map that creates more opportunity for African Americans, but simultaneously preserves 5 white majority, or at least 5 Republican leaning districts, which of course is physically impossible. There's only so many districts. And if you create an additional African American majority district in a southern state like Louisiana, there's going to be one less Republican leaning district. That's just the way the politics and race interact down there in the current world that we inhabit. But that essentially makes it impossible to have any kind of gains for the African American population in terms of representation, because it's a zero-sum game. There's going to be somebody who loses representation in a way that loses some of the representation they had in the state's map. Is that a fair summary?
Yeah, that is. I mean, effectively, what is happening is that Black voters in Louisiana, and now unfortunately across the country, are being punished, are being penalized because we vote more with the Democratic Party than the Republican Party. And, I've written about this. I wrote an article in NYU Law Review called Parsing Partisanship, that you need to parse the association, the expressive interest in affiliating with a political party from the doctrine that says, yes, you can gerrymander based on partisanship. Because if you have what we call conjoined polarization. If you have a racial group that tends to vote with a political party more often than most other voters, which is the Black community, and you say you can elevate partisan interests over every other, including ensuring that all racial groups have a fair opportunity to elect candidates of their choice, you are effectively locking Black people out of power permanently. You are elevating partisan interests above all, above the right to vote, above separation of powers, because remember, Congress already addressed this issue through the Voting Rights Act and said, we actually want to make sure that there is a competitive process and all voters have an opportunity to elect candidates of their choice. And you also, the court did in this particular case, it elevated partisan interests over its own precedent.
Right.
Stare decisis, because it had already decided this issue in 2023 in another case that LDF brought, Allen versus Milligan, on nearly identical facts.
Right.
So this is an alarming decision in every respect.
The stare decisis piece is remarkable because the court has traditionally said, if we're interpreting a statute, especially a statute that's had a particular interpretation over decades and Congress has not indicated any problem with that interpretation, the stare decisis is almost mandatory, that you have to follow that interpretation. If somebody wants to change the law, they should go to Congress. But they just completely ignored that. The other thing I was going to say is, as a person who tried to get rid of partisan gerrymandering in the Supreme Court about 3 different times, what's frustrating is that we start 8 years ago, the court held in the Rucho case that partisan gerrymandering is probably unconstitutional and is terrible, but we can't establish clear enough standards, so we're not going to allow it to be litigated in federal court. Now it's become a positive right of the state to be as unfair as they want to be, and we have to honor that like it's an affirmatively good thing that takes precedence over racial justice. It's really quite amazing, actually.
It's stunning. It's stunning. It's shocking and absolutely appalling. Paul, I remember your excellent argument, and you're right. At least then there was a joint assumption on the part of, I think, all parties that this was not a good thing. Partisan dominance in the redistricting calculations was distortive. It was potentially unfair. But it was sort of the thing that you just couldn't control, or at least not at the Supreme Court, that states could perhaps regulate it, that Congress could regulate it in its own way, but that the Supreme Court just, wasn't going to enter the political thicket, right? It was non-justiciable. They wouldn't enter the thicket. They're now in there issuing invitations to political actors to carve up districting lines to cement power in ways that I think are going to be utterly intractable. And it's a very dangerous position for our democracy.
Yeah, no, it's going to be really terrible to watch the effects of this as we go on, and we can talk a little bit about that in a minute. But I wanted to note that the court, at least as a formal matter, decided this is a statutory interpretation question, although the underlying constitutional concern was sort of motivating the rewrite of the statute. Wonder why they didn't just go ahead and hold Section 2 unconstitutional, the results test of Section 2. Why do you think that they, at least as a formal matter, did it as a statutory interpretation and gave these new versions of the Jingles test that are unmeetable, but they still pretended like there's a statute out there that could still be used?
I really can't think of any other reason than public deception.
Mm-hmm.
I think it's a fig leaf. I think it was an attempt by the court to not basically unleash a backlash that would be, I think, uncontainable by saying outright that they struck down the Voting Rights Act of 1965, or at least this core provision of it, Section 2. And what I think is important for all of us who understand what this decision means is to say what it does mean, which is that they did that very thing. They struck down Section 2 of the Voting Rights Act. They struck down the final provision of that act that had any real meaning. Now, as folks who have been in the academy or who are in the academy, yes, we can conceive of a claim that in theory could pass the new test that Justice Alito and his 5 joiners agreed to. But I can tell you for sure and for certain, as someone who has litigated these cases, the work that Section 2 has done for the past 40 years would have been impossible under this new test. So whatever remains of it is nothing that resembles what has created the multiracial democracy that we now live in and enjoy, and that is now deeply under threat.
Right. The model for how they do this to avoid that headline about holding the act unconstitutional was Alito's prior opinion in the Brnovich case, where he addressed Section 2 in its other application to laws that have have a disparate burden on various racial groups in terms of how they access to voting. And he came up with 5 different kind of standards you have to meet that make the statute pretty close to unusable for that purpose as well. And so he, when the chief gave him the opinion, I think that was the plan, to make it sort of a pretense of statutory interpretation. What the great irony is, what he said ultimately is we have to do this because otherwise the statute's unconstitutional. But what's happened in remarkable fashion is the amendments that were intended to make our democracy multiracial and allow full and fair opportunity for African Americans and other people of color to vote have become the tools that they use to prevent those very measures from working.
Yeah, it is ironic, to say the least. And what I think is most dangerous about this decision is that it is in many ways an attempt to rewrite the 14th and 15th Amendments. One other aspect of the decision that we didn't touch on directly is that as part of the very robust test to show that a districting map is discriminatory, once you clear all of the preconditions and you get to the meat of the case to show the discrimination, Justice Alito also said, you can't really look at past discrimination at all. Let's only focus on recent, current, immediate discrimination when you're looking at the construction of a map. And that really misses the point of the Voting Rights Act, which was meant to undo the years of discrimination and violence and other methods of keeping Black people from the ballot. And I think back to what Chief Justice Roberts wrote so poetically in Allen versus Milligan, when he said, before the Voting Rights Act, the 15th Amendment was a mere parchment promise. I thought it was such a beautiful phrase. And what he has done is render the 15th Amendment a mere parchment promise yet again, because what was standing between the century plus of disenfranchisement and the Voting Rights Act, which enabled people, and Black people in particular, to participate in our democratic processes on an equal basis, was that very statute. And now Section 2, Section 5 are both gone, and we already see what's filling its place. And it's
right. Well, the mechanism seems to be this notion that the real meaning of the 14th and 15th Amendments is colorblindness. Anything that is intended to actually remedy the past, the sins of the past, and help people have a full and fair, meaningful vote that has anything that is itself a constitutional violation, because it is noticing that some racial groups need this support and protection, and therefore violating the colorblindness principle. It is, and it's essentially the same thing they did in the affirmative action case. Oh
yes,
it's all of a piece.
It's all of a piece.
Yeah. The question I might ask you now is, well, first of all, what's your assessment of where we're going to be in not necessarily this year, but in 3 years, in terms of African American representation in the Congress and in the state legislatures as a result of this opinion?
Well, if there's no intervention, if there's no change, and this opinion lives out its course, we will be in a dramatically different country. We will be in a country where we will be hunting for representation that looks like the increasingly diverse population that we are. We will be in a state where a majority of people in this country are not represented by people who represent their interests and who are aligned with their viewpoints. That is a recipe for chaos. It's a recipe for anarchy, and it is a recipe to completely unravel our democracy. And that's not hyperbole. You look at what's already happening in many places across the country in the wake of this decision, and you see extreme partisan gerrymanders at the expense of voters who are racial minorities. They will soon become a plurality in this country and will still be locked out of the political process because the lines will have drawn them out of it. That is a cocktail of tremendous threat for the viability of this country.
Right.
And that's what worries me the most.
Right. And we certainly are seeing the short-term the signs that it's going to be used as effectively as it can be by the people who want to push toward that very set of conditions, with Memphis being carved up 3 ways already for so the African-American population of that city has no opportunity. The elimination of a district seems to be happening in Alabama as well as, of course, in Louisiana. And I think, there's talk of taking away Representative Clyburn's district in South Carolina. That might be a mistake on their part. But there doesn't seem to be any shame about going ahead and using this thing as quickly as they can to eliminate opportunities for African Americans, especially in the South, to be represented. Do you have a theory about what happened in the 3 years since Allen versus Milligan? I mean, that case written by the chief, it seemed to have decided all these issues the other way.
I do have a theory. It's a pretty short one, and it's called November 2024. I think if you look at Allen v. Milligan and you look at Louisiana versus Callais and you say, what intervening event occurred? What's different? The composition of the court didn't change. The composition of the country really didn't change dramatically. There were no significant legal developments, but there was a new administration that made it very clear that it wanted to redistrict the country in a way that would provide a shield and that would benefit a particular political party. That's the only thing I can point to. There's really no logical reason for this decision that we just experienced. And the only thing that can really change that is if we get new legislation that makes very clear Congress's authority to ensure that our multiracial democracy proceeds, probably in a way that gives some clear nod to the Callais decision and navigates this gauntlet of tests.
That's going to be a tough one.
It's going to be a tough one, but we've got to do it. I mean, there's no other choice.
Right.
Well, we need a Congress that will do that.
It is a daunting prospect, seeing what really the effects are going to be on our democracy, and then trying to figure out what kind of a solution. Maybe there's a legislative solution. I think a lot of people will be skeptical of that, but it's certainly, you got to keep trying. What else can we do? I guess that's the question. I'm sure people have been asking you, Janai, in the last 2 weeks. What else can we do? Obviously, people who care about racial justice and democracy in this country aren't going to give up.
No,
they didn't give up in 1950. They're not going to give up in 2026. But what else can people do who want to try to help stand up for basic American values here?
we have to engage, and we have to engage in a very concerted, collective, and committed way. So one is, obviously, we all need to make sure we are registered to vote. We need to check that registration early and often, because there are efforts to remove people from the voting rolls, but that's just the bare minimum. We need community commitments. where entire communities are registered to vote and are going to actively participate in our democratic process, not only by casting a ballot in primary and general elections and all of elections year round, but holding elected officials to account, making demands for legislation that will be a corrective. And that can be both at the federal and state level. We've had great success getting state voting rights acts passed, and there's a lot more interest in them, especially in the wake of the Louisiana versus Callais decision. And so we're seeing an uptick in interest across the country, even in places like Alabama and Louisiana and Mississippi. So we are pressing forward with that. But we also need to think about alternative voting systems. We need to think about what is going to serve our democracy. And we need to put the idea of proportional representation back on the table. We will be a country that is extraordinarily diverse, that will have a population as early as 2042. Some people are saying 2040. That will be a plurality of people from different racial and ethnic backgrounds. And everyone should have a shot at representation. And that's something that we can think about. This is a moment for us to rethink democracy, for us to refound our democracy as we approach the 250th anniversary of the signing of the Declaration of Independence. So this is a time to engage because our democracy is imperiled, it is under threat, and it is soon to become unrecognizable.
Yeah. I mean, the other thing I would just suggest is we need a pro-voting rights Congress, and we need it right now. I mean, this is obviously there's no hope in anything for a Congress that's unwilling to stand up for those principles. Well, you know, in the end of the day, even if we can get something good passed, the Supreme Court's out there showing that it's willing to be pretty aggressive about taking everything down. But at least that's where the fight has to begin. As you say, it can also happen at the state level. But everybody needs to get involved in one way or another in this fight, because this is really a red alarm emergency. This is really terrible for our democracy. This is a decision, as you said at the beginning, historic because what it does is it takes us back to pre-Voting Rights Act days. What does that mean? It means people really, African Americans in the South in particular, but not just in the South, will have the right to vote, but they won't have the right to cast a meaningful vote in many, many elections because of the ability of the people who draw the lines to carve them up and disperse them in ways that make their vote essentially useless. That's the reality, and I appreciate, Janai, you're taking the time out of your busy schedule in what must be a crazy month for you to talk to us about this really profoundly important issue. And I think, is there anything else you want to say while we have the benefit of your wisdom here?
Oh, thanks, Paul. Well, I would add one more thing to your prescription. And not only do we need a Congress that is pro-voting rights, I think we need a Congress that's pro-court reform as well. We have a real issue with our Supreme Court, and on this issue especially, but on many other issues. And we need a Congress that's going to look at our federal judiciary and find a way to increase public confidence, ensure that it issues decisions that have integrity and not, based on a shadow docket where we barely can argue and there's no opportunity to really present evidence or anything along those lines. There's a real overhaul that needs to happen across the board. And so that is just as important in my view as any other prescription.
Well, thank you, Janai. That's obviously a very important point as well, because if the court's just going to take everything down and whatever people try to do to restore equality, then we're going to have to deal with the problem of the court itself. But we really appreciate your being with us. Let me also say thank you to all of our viewers here for your interest in this incredibly important topic. I hope you'll stay involved in one way or the other. One way to stay involved is with the ABA section of Civil Rights and Social Justice, which I'm going to be chairing next year, and I would appreciate all the help I can get. Obviously, organizations like the Legal Defense Fund and many others are out there waging the good fight. as well. The key thing is if you care about civil rights and social justice, don't just watch a Zoom once in a while. Get involved and play the role that each of us individually can in this democracy, which is still a democracy, even though it's not as great a democracy as it was 3 weeks ago because of this really terrible decision. Thank you, and appreciate you all watching, and thank you again to Janai. Take care.